I'm Alex Howard.
And I'm Amanda Silver, and this is Dirty Laundry. Today on Dirty Laundry, we have Miriam Mandhane from Mandhane Family Law. She is a family law lawyer, an advocate for women's rights. She's worked for the United Nations. She's a published author, and she is here to talk all about the tort of family violence. So welcome, Miriam. So welcome, Miriam Mandhane. Welcome back. Welcome back to Dirty Laundry and in person.
So much better.
The last time you were on, you were Zooming from Bosnia.
Yeah, from Sarajevo.
Wow. Okay, so she's come all this way just to be on our show.
I have.
And what a time to come. There are some exciting things happening in Canada. So let's talk about it.
Yeah, this is like a continuation, really, of where we left you last time.
Yes.
And we're still kind of waiting.
Yes, but the wait is almost over.
We're almost there.
Over.
Yeah.
So let's recap.
High conflict, coercive control, family violence, all that jazz in family court. But then we also touched on the Ahluwalia and versus Ahluwalia, I hope I'm saying it right, case, which is now in front of the Supreme Court. And we talked about Justice Mandhane's decision that was, I guess, overturned by the appeal court, and now it's gone to the Supreme Court. So we're here to talk about it because any day now, maybe even by the time this is released, we will get the decision.
So when we made this date, and we decided to have this in-person session, we did not yet know that the Supreme Court of Canada had issued their decision on Ahluwalia. However, since then, and I think I checked their website yesterday. And so what they've done now is they have issued, since I think it was the 13th of February, they issued the media lockdown letter, which means that they're basically calling on the media to come in and read the decision before it's released to the public so that they can accurately report when it's released.
I was gonna say, so how do we get invited to those decisions?
But that's a common practice then, I'm assuming.
Yes, I didn't know that. I didn't know it was a common practice. And my private investigator who works with me on cases, she's actually the one who sent me the link, and she said Ahluwalia is coming down.
It's coming.
And so I looked up, she sent me the link, and I just see like media lockdown, and I'm like, I had to help. I got ChatGPT, of course, to tell me what that is. But so then, yes, she said, well, they've lined up the media, and so it's been written, and it's the media have been informed that they need to come in because they need to sign an undertaking that they're not going to report on it until it's been it's been released to the public.
Fair.
But they've I guess essentially like during this time, it's done. It's done.
And what do we know of this judge? Like, is there
Supreme Court? So it's a whole bunch of them.
A whole bunch of judges. Yeah. Thank you. But it doesn't have to necessarily be all of them, right?
I think they have to be unanimous in their decision.
No, I mean, it doesn't have to be all of them. It will, if anyone dissents, that will be there has to be a majority for for the decision
majority,
to
not
be
unanimous.
Right. But they can have dissenters. So they can have like 3 judges, for example, that dissent. So I don't know how this is going to be. I have great hopes for this decision. I happen to be before Her Honor Justice Mandhane last week. And so that's when I realized that the entire time I'd been talking about this case, I'd been saying her name wrong.
I think I said it wrong today already. I'm sorry.
I also said it wrong. So yeah.
If you're listening, I'm sorry.
It's Justice Mandhane.
Come on our show.
Yeah.
We'll make it up to you.
Yeah. So that's what I was so like, I was fangirling. I was so fangirling.
I expect.
Yeah, I was super fangirling, but I didn't let her know that.
No.
Also because she wasn't happy with me at that hearing. But anyway.
Are they ever happy with you? I feel like the judges are like, they're
so
not always
serious.
like nice. The family law judges, like they're always like irritated. Why are you here?
I think there's, not specifically about her. I think she'd had on that particular day, she'd kind of had a hairy day because the people before us went way over time. And so then we were waiting, and it just meant that, and then lunchtime ended up being late. Anyway,
was irritated.
She was
angry.
She was
but
irritated.
So I mean, actually, it was my fault because I hadn't uploaded properly my documentation only because so there was an administrative issue. So I can't let her. I have to fall on my sword for that one because I did. But in the end, it all worked out well, and I got to find out how you say her name.
Okay.
So it's Justice Mandhane, and she is. I think judges are a lot of them are commonly irritated because I think a lot of times people become judges. They're so excited. Like they're you have to be ambitious, right? And because you apply to be a judge, right? And so I think people, like, as a lawyer, the last thing I want to do in the, after I've already practiced family law for years is to do it more all day long, every single day.
Yeah.
And I think that is something I definitely am not judge material. I'm very advocate material.
Right.
I am an
Definitely
advocate.
advocate side.
Yeah. And I don't know how I would feel if, it's very stressful what I do. I mean, I always, I have a very stressful job.
Yeah.
And so I can't imagine being me and then having a 9 to 5 where I'm constantly bombarded with cases.
Yeah.
And a lot of these judges have had successful practices or were part of successful practices. So they're kind of like taking a pay cut and a more work,
less pay to serve the public. Basically, it is considered a privilege and an honor to do it, but with it comes
some great responsibility
and sacrifice.
You get to but you get to advocate for your clients, for the law that you can see is not really supporting your clients. Once you're in that judge's role, now all of a sudden you also know how the sausage is made, and it's almost more difficult to stay, I think, unbiased or neutral or take in just the evidence. And yet that's the expectation. And if most of the judges are coming from a practice where they, again, were one-sided, to switch, I don't know, I would imagine it would be very difficult and a different kind of role, a different hat you're wearing. And after, however many decades of wearing one, it would be a difficult switch.
But Justice Mandhane,
yes,
that's how you say her name.
Nailed it.
She did something different, I think, than most judges typically do, because I feel like judges are tied, their hands are tied a little bit, right? They're tied by the law, by precedent, all of those things. So they're, correct me if I'm wrong, less likely to reinvent the wheel.
Yes.
Right? They follow
or be creative.
Or be creative or step outside the box, because with it would come scrutiny and
great responsibility again.
All the things that come with it. But here she did. She created a new tort.
Yeah.
So let's talk about what the heck a tort is, first of all, for our listeners, and what she did that was so groundbreaking.
What's really, I was just, when I was scrolling this morning, I just saw a reel that was by a lawyer on a legal Instagram page. And he was talking about fear. And he was talking about how lawyers are constantly instilled with fear. So in law school, you're instilled with fear. You're looking at, you're reading about cases where things have gone wrong. Right. And then you come out and you're instilled with fear that, of your, the law society or whatever that is, and wherever you practice, you're instilled with fear that you're going to do malpractice, right? Negligence. You're instilled with fear that your client's going to come after you, and you're constantly being told you have to cover yourself just in case the client turns. Right. And so there's this culture of fear surrounding our profession, which doesn't allow for creative thinking, which makes it a lot more difficult, and the chances of thinking outside the box are kind of snuffed out by this environment of fear. And I thought that was so interesting that I just happened to come across that reel as I was scrolling. Yeah. And I thought of Justice Mandhane, and I thought to myself, imagine, she is a woman of color. She's become a judge. So right there, she's already, outside of the box.
Yeah,
she's a woman. She's and she's now set this precedent. And family court and family law is one of the most kind of sensitive types of law. And where Justice Abella Justice Abella used to sit on the Supreme Court of Canada, and she talks about family court being where all the ugly is seen, right? Like that's where all the ugly is truly seen. Yeah. And so for Justice Mandhane to take this kind of a step and set a precedent in kind of the most sensitive area of law is like nothing nothing short of heroic.
Yeah.
As a judge, as an individual, as a woman.
So brave.
Yeah, so heroic. And Justice Mandhane was a U of T law school graduate. I have a friend of mine who was in law school with her. She's a genius.
Yeah,
She's
no doubt.
super smart.
Yeah.
Like she's like she has
Giving RBG.
Yeah.
Right?
yeah. She's definitely like, if anyone has earned her way into this position and into being able to set a precedent, it's Justice Renu Mandhane. And so I think she has that to back her up. But I also think that when you step out of the box and when you do something creative and you set a precedent in a very conservative, stuffy institution that is very patriarchal, like we have to be honest.
It is, yeah.
I can't imagine that a lot of people wanted to sit at the lunch table with her. I'm just going to say it.
And that's where the change happens. These, if you look back historically, it's the people that stood out, that went against the grain, stood up and did something that maybe wasn't popular, or there would be some fallback. That's where the most beautiful change happens.
Yeah. And I think what was, and especially since, that case was then taken, she was a new judge when she set that precedent.
She was a new judge.
She was extra ballsy.
Because that is pretty, right? Like you think a judge who's been on the bench for a while sort of is more comfortable in their position and like a bit seniority, but a new judge kind of is still proving themselves.
And Justice Mandhane is really singular in her decisions, and I want to tell everyone that's watching. I don't know where am I supposed to look at it, but I want to tell everyone
everywhere.
If you're watching and you're researching Can Lee, look up Justice Mandhane's decisions, because what she does is a very deep, thoughtful, intellectual, legal exercise of shoring up all of her decisions with law and evidence in a way that makes them almost kind of
indisputable.
Indisputable. And and one of the things I always tell my clients, and I talk about it on my Instagram page, is go into Can Lee and look up certain judges. And then when you draft your own materials, and I do this myself, draft the way that they've drafted.
Just like a template.
Yeah.
Smart.
Okay.
And so Justice Chappell also, she's now retired, which was a huge loss for our system. Justice Chappell was also incredible. Hamilton Superior Court of Justice, incredible decisions, incredible reasons for judgment, like just so deeply intricate and well written. And I think that it's important for us to read the decisions, because we can read them. You don't have to be a lawyer to read them.
You can just search it through the name or through the subject
matter.
Yeah,
we can link to it. Let's put them in the show notes for sure.
Right, absolutely. Yeah. And so what Justice Mandhane did was, she was the trial judge at Superior Court of Justice in Brampton for this matter, Ahluwalia and Ahluwalia. It was a husband and wife, and it had been a long-term marriage. I think it had been something around 20 years. Yeah. And what she said in her decision is that the torts, and I'm going to talk about what torts are, but the torts that are available to us, such as battery, assault, intentional infliction of mental distress, negligence, those torts are not sufficient, and they don't cover. And the way I want to, I'm going to paraphrase because I don't remember exactly how she said it, but it's the cumulative harm that comes from a pattern of coercive control that goes to the heart of family violence.
Yeah.
Wow. I mean,
it's so articulate. Even your paraphrasing was so articulate.
That gives me the chills that this is being, like, it really does.
Yeah.
Because I feel like it's never been talked about or seen, or there's been no acknowledgement of the harm that is done. That long-term, slow build and that, or breakdown.
Breakdown even,
Yeah.
Yeah, and so they're trying to assign other torts that speak to violence, but are not, they don't have the pattern and the longevity. It's not like, oh, I was in a bar fight and now I've got, now I'm being charged with assault and battery. That was just a one-off versus this 20 plus years
of a bar fight every single day of your life,
of living in perpetual fear at the place where you're meant to be safest, your home, with the person you're meant to be safest with, your partner. Oof.
Wow. Okay. So
So
The
to
tort,
be clear,
wait.
this is just coming from the judge in her ruling. This is not the lawyer pushing it, like for Mrs.
Well, the
Ahluwalia.
lawyer did
Okay,
plead
that's-
that.
okay.
So
Okay.
Mrs. Ahluwalia's lawyer pled damages
Okay.
for all of the harm. So damages
Mm.
is, when we talk about torts and damages, this is generally speaking, not always, but generally speaking, this is the language of personal injury law
Right.
and civil law,
Right.
right?
Okay.
So it's the language of, for example, your doctor did something wrong and you go to a personal injury lawyer.
right.
And that personal injury lawyer usually, will if they win, they will win a settlement for you based on
Right.
the wrongs that doctor did,
Right.
right? And they will, and that generally speaking, in medical malpractice, it's
Right.
it's negligence,
Right.
right? It's not, and then they're insured.
Right.
So if they work for a
Yeah.
hospital, they're insured. As a
Yeah.
doctor, you're insured.
Lawyers are
As a
insured.
lawyer,
Yeah, as
you're
well,
Yeah,
yes.
health professionals are.
Right.
Are, yeah.
And so they will then, the judge will, if they don't settle at a trial, the judge will apportion and order damages. So damages are money,
right.
right? Money for the negligence done. And
Right.
case law has really, in the personal injury world, case law has really clarified how much you get for, like, if it's your finger, a finger is worth
Wow.
$15,000.
Right.
Like a burn of this nature at this part of your body is worth this much money,
Interesting.
right? So because personal injury
Yeah.
law is very
Right. How much is a death? How much
Yeah,
is
right,
a
and-
lost an
Yeah,
arm
lost
or
a limb,
whatever?
yeah.
Yeah.
right. And so this has been over and over, case law has clarified
Right.
this over time for personal injury law. So personal injury law kind of has a formula
Yeah.
a little
Right.
bit, right?
Right.
Yeah.
Whereas this, a new tort, a new wrong
Yeah.
of family violence, doesn't necessarily yet have, and she just set that precedent with
Right.
that case. And she awarded Mrs. Ahluwalia $150,000, which I believe was, if I'm not wrong, and that's my jet lag in my memory, but the entirety of the house. So
right.
so her
Oh.
damages, she was awarded damages for the family violence that she experienced,
Right.
and those damages came out of the family
family
home,
She
property.
the
shifted
house.
the equalization.
Yeah.
Exactly.
She didn't say to him, "You have to pay an additional $150,000 and go find it." She basically took their net family
Yeah.
property statement and just shifted it.
Yeah, and she
Which is
gave,
interesting.
Yes,
Yes.
and
Yeah.
because so this is interesting, and
Yeah.
I'm glad you brought up this point because it just means that the tort of family violence can only be pled at this point. It can only be pled in the Superior Court of Justice where property issues,
Right.
where there's jurisdiction
there
over
is.
property issues, because there's got to be something
Yeah.
to take it out of,
Because
right?
there's
Like,
no insurance.
Right.
We
Then
don't
they
have
have-
marriage
Right.
insurance
Right.
for when we get divorced, so we have to
Right.
pay out.
Right.
So
okay.
then what happened is that Mr. Ahluwalia, needless to say,
Fought back.
yes, he fought back. And I mean, listen, this is a very sexy case, right?
Yeah.
So the lawyers who are working for these people are not getting paid.
Totally.
Right?
I was
Like,
wondering
it's-
if they're on
Yeah.
contingency or
Yeah.
it's just so
It's
it's so high
just-
profile that it's like they're
so
getting
high
their names
profile.
out
Like
there,
you
right.
get to go to the Court of Appeal, you
pretty
get to the, like
exciting.
everyone,
Yeah.
right? And I mean,
It's like the Super Bowl of family law.
Yeah.
It really-
So,
Yeah.
so I cannot imagine that Mr. Ahluwalia paid his lawyer,
Right.
who I know, the thousands of dollars
Yeah.
that would have been his bill, because
Which is a really important reminder, actually, for the listeners, because we know what legal fees can be.
Yeah.
And so there is an incredible barrier to entry for a lot of families that maybe can't afford a lawyer or one as savvy to come up with a defense against this or for it, or,
It's such a good point because if you get hit with one of these torts or these damages of, let's say, 50,000, 100,000, to hire a lawyer to go to the Court
Yeah.
of Appeal is going to cost you more.
more.
Than that.
Oh,
It's going to cost you
yeah.
hundreds of thousands
Yeah, it's a
of
drop in the
dollars,
bucket.
right?
a Court of
Yeah.
Appeal.
So you can't
yeah.
afford, unless you have some lawyer who wants to take it on pro bono,
Yeah.
because this was the exception.
Yeah.
You can't go. You
No.
can't fight that.
Even trial, like even the fact that Mrs. Ahluwalia made it to trial
Is
is huge.
Yeah.
And I want to talk about that as well, because I want to talk about the fact that what do we do with the tort of family violence in a situation where we're also attempting not to go to trial, right? Because
Right.
that's the goal in any family. Like, we don't want to bleed the client to get them to trial unless we absolutely have to. And so the case of Ahluwalia raises a lot of questions because what do we do with the tort of family violence for our clients while at the same time we don't want to go to trial?
Oh, it's so
where
interesting.
it's at trial that these determinations will be
Right.
made.
You won't get that tort decision until you're at trial.
Right.
You're not going to get on a temporary motion or anything like that. You're not going to get to the last stop.
But these are the example, like these are the kinds of files that change the law potentially.
Exactly.
Right.
That move us forward.
Right. And so and I just really want to quickly talk about what the Court of Appeal said, because what the Court of Appeal actually said really showed, it was a case in point, why we need the court, even though the Court of Appeal overturned Justice Mandhane's precedent. Their decision actually showed clearly why we need that why we need the tort of family violence. And I watched both of those. I watched the Court of Appeal arguments. I watched Supreme Court of Canada, and at the Court of Appeal there was a very young and exceptional appeal lawyer, Brooke, and I forgot her last name, that was for Mrs. Ahluwalia.
Okay.
Her first name is Brooke. I'm so sorry, Brooke, that you know who you are, and you're amazing. But she started out, and when you're at the Court of Appeal, it's basically, or at the Supreme Court of Canada, like there's no more witnesses. It's just you making your argument and the other side making their argument to the body, the Court of Appeal or the Supreme Court of Canada, and the judges can ask you questions.
Okay,
right?
So you're on the witness stand, essentially.
Yeah, essentially,
as the lawyer, right? You're defending. You're the only person defending that case,
right? And Brooke came out and she said, "Your Honor, Your Honors," because it was a panel of 3. This is a harm that is tantamount to death by 1,000 cuts.
Yes. Wow.
Right?
Yeah.
And it was so powerful. And I mean,
it's so true.
And it was so powerful. And she really, and not because of the fact that it's not my bias. It's just the fact that her arguments and her delivery and her, just everything about her, and that team that she represented. There were other lawyers and I forget who they were, but she was so exceptional that I remember her so distinctly. And Mr. Ahluwalia's side just did not.
It couldn't,
but they won. Essentially, they won. Right?
That's right. They won the.
It was overturned.
It was reduced to 100. I read it was reduced to 100,000 from 150,000.
Yeah. So but they didn't. So it was. But what was interesting about that as well is that it didn't go. It was just one of the damages. I believe it was the punitive damages that were overturned. The other quantum of damages were maintained. So while the tort was not upheld, the quantum of damages was maintained to a certain extent. It was just the punitive that was, I believe, reverted back to Mr. Ahluwalia.
Wow.
So basically just reverting that tort.
Or the amount that it would have covered, I guess?
Yeah, so the amount the amount that was given to Mrs. Ahluwalia for damages was, the concept of the damages was still maintained at the Court of Appeal. So the Court of Appeal still gave her damages.
They still recognized that she was a victim of intimate partner violence and domestic violence.
Yeah,
and so they still upheld that.
But they didn't uphold the new tort of family violence.
It almost sounds like they didn't want to acknowledge the intimate partner violence. It sounds like it was easier to go, okay, well, this is like battery or assault or something that was pre-existing in a criminal law sense that people could wrap their heads around. So the same amount of damages, but not actually validating or upholding the new tort.
The ideological foundation, right?
Yeah.
And so, and what they said was that it's legislature who should decide.
Sure.
Right? This was their
Pass it on to the.
they
Well, that's
kind
why
of
we keep having MPs on. So
Yeah.
let's change
Yeah,
it.
we
Let me change the law.
exactly.
and you know, like it's an argument to be, it's a defense
Yeah.
for you know, you can say that about anything,
Yeah.
right?
Someone else's problem.
Yeah, you can always say
You can
that.
always kick the can.
Right?
Yeah.
Yeah. But what they said was that they so in the appeal decision, they're like, look at all these cases, family law cases, where torts have been pled and were successful. Okay? Look at these. Like we don't need a tort of family violence because we already have all of these
precedents.
torts available to the public.
Okay.
And look, this case.
Right.
So what those cases were really what unified those cases is that there was one event that was catastrophic, right? Where
The
you
inciting
could
incident.
and you
a hospital
could
visit,
or like
police,
yes,
right,
and where
something-
you could quantify the damages. Like
Right.
she didn't go to work
right
for 6
Right.
months,
Right.
Based on the personal injury
Based
law
on-
playbook.
yes.
her head was cracked open,
Yes.
or like
exactly.
That's this much money. Lost a
Right.
finger. This much
Exactly.
money.
So
Interesting.
realistically, even though they kind of sucked and blew,
Yeah.
so they were sucking and
sucking and blowing.
Like, where is she going with
so,
this?
yeah.
This is dirty
Not
laundry
going
after
there,
all.
not going there. Yeah, yeah. But so we knew that this decision was going to go up
Yeah.
to the Supreme Court of Canada.
Yes.
Like this
Yeah.
was obvious to us once we got the decision from the Court of Appeal. We knew that this was going to keep going up, and so the extremely fabulous and able Julie Hannaford was Mrs. Ahluwalia's lawyer for the Supreme Court of Canada argumentation and arguments and she basically represented Mrs. Ahluwalia at the Supreme Court of Canada. My friend Ange Pagano also is number 2 for Ms. Hannaford. So yeah, it's very like I get to call her and say, hey, Ange, is it coming? What's going on?
Exactly. Get the inside scoop.
Hope Netflix is circulating.
Right.
Yeah, Netflix
Is it
like
common
this.
to switch lawyers at different
Yeah,
stages in the
yeah,
process?
because when you get to the Supreme Court, you want Julie
You need-
Hannaford.
you-
Like,
right,
you know what I mean?
right.
Like,
There's
you-
certain people who have. You need someone who's been in front of the Supreme Court. I would
yeah,
assume
and
before.
who is
knows-
like,
Yeah.
you know, she's an
ins and
incredible
outs.
lawyer. She's an incredible family lawyer, right? And she's an incredible litigator,
Yeah.
and she has a lot of, you know, she just holds a lot of credibility in the community, right? So and she's and obviously I think I'm almost, I don't know this for a fact, but I'm sure she did this pro bono because I can't imagine Mrs. Ahluwalia
Right.
is in a position,
Right.
right? And so she's able to do that, right?
Right.
Like, I mean, she's in a position that
Right.
she's her firm is able to do that,
Right.
which is great and
Right.
it's amazing because without that, Mrs. Ahluwalia would not have been able to go to the Supreme Court of Canada.
And thank God they're doing this because if they're should they be successful, and we hope that they are, then that will help others not have to go there because it exists. Right?
Exactly.
Just the fact that if the tort could exist is enough to keep people from trial.
Well, this is the
Right?
interesting thing in my perspective, going back to the whole idea of like, oh, well, we should be changing the legislature to try to avoid having to use the court system to make change, since really we, I think all collectively are trying to keep our clients out of court. So it's kind of this like,
Someone's got to be the face of this,
yeah.
and someone has to sort of take one for the team.
right.
And that's this situation, right? Where she's taking one for all of the domestic violence victims who have come before her and who will come after.
and
her.
Right.
who will come out.
And
Yeah.
you know, and this every time there is, I think everyone should be cognizant of the fact that the reason we are where we are in family law, and I know a lot of people are really frustrated about it, and I am too, but the reason we also have to look at the strides and the progress made. And the reason we are where we are is because somebody took one for the team.
Yeah.
And that we have to really be cognizant of that and be so grateful. It's sacred.
Yeah.
It's such a sacred fact to be aware of, right? Like
Yeah.
Rosa Parks.
Yes.
Someone took one for the team
Yes.
and it was Rosa Parks.
Yes.
Yeah.
Right. And so it's heroic, and we have to be
Very.
cognizant of how heroic it is. It's heroic of Justice Mandhane.
Yeah.
It's heroic of Julie Hannaford. It's heroic of her office. It's like
Of
all
Mrs. Ahluwalia to be the face of
Mrs.
this.
And have
Ahluwalia.
her name spread all over the country.
with her the inside dirty laundry of
Right.
what was going on
Yeah.
behind closed doors.
And I don't think people realize
Yeah.
just how difficult that is until they're in it. Like when you're
Yes.
looking at a situation of that, like that, and you're looking at Mrs. Ahluwalia, you don't see her parents.
Yeah.
You don't, who are maybe saying to her, like, what are you
Exactly.
doing? Like, why are you
Yes.
shaming us? I don't
Right.
know. I'm just saying.
Yeah.
You don't
Yeah.
see her kids who might be saying, why are you doing this to our dad? I don't know. I
or
think
who are being picked on in the schoolyard
Right.
or whatever.
Yeah. And I think actually her kids are,
I think they're supportive.
Yeah, they're
I heard
supportive
her
of her
speak
mom.
a little while ago.
yeah.
Yeah, I think they're,
But there's a
supportive of
lot
their
of
mother, but-
there, her community, like that
Yeah.
community is it's a tight knit community.
very
There's a lot-
family oriented.
right?
Very
You
modest.
deal with things on in the
right?
the
Like don't
confines of your
throw out
home.
your dirty
Exactly.
laundry.
Exactly.
Yes,
right?
Don't shame
For
us.
sure,
You
for
Don't
so
shame
sure.
us. And I think there's
Yes.
so many communities, right?
Yeah.
That are like that, and that there's like, and the misogyny doesn't come out until push comes to
Yeah.
shove, and then you're like all these people who were virtue signaling and posturing and posing, and
Yeah.
you thought they're suddenly, and they're suddenly not who you thought they were.
Yeah.
And I just, a very close friend of mine, who's no longer a close friend of mine, when I told her about my situation of abuse with my ex-husband, she said, I'm embarrassed to be your friend. And we're no longer friends, but
I should hope not.
yeah, no, obviously, yeah. But I mean,
Whoa.
she was the last person that I would think would say something like
Yeah.
that. So you just really find out where everyone says, like, when you go through something really difficult, you find out who your friends are. And I didn't think this would be the difficult thing where I would find out who my friends are. I didn't think it would
Right.
be that.
You didn't think that was controversial.
I didn't think
Women just stand by each other.
Yeah.
They don't know.
No,
Right?
We see in the world right now, we see a lot of the white woman syndrome, and it's embarrassing. As a fellow white woman, I am often going, "Are you insane?" But you do. You see people's true colors.
You see
You
people's
see the
true colors.
second something could be pulled away from them, some of their privilege taken for granted and changing, and it starts to hit home more
And
so.
And for Miss Ahluwalia as an immigrant woman,
Yeah.
Right.
she's already got challenges
Exactly.
Right.
and
So
obstacles
many.
and barriers.
Right.
So
Yeah.
it's even more, groundbreaking, really.
Really. And so I think this is I mean, I love my country. I love Canada. I'm so grateful to this country for having allowed me and my family to come and thrive and be able to defend, I'm a Baha'i. That's my faith. And I'm able to go to the IRB and argue for the asylum claims of people from my faith group who are highly persecuted in the Islamic Republic. And so I love that I'm eternally grateful that I'm able to do this and I'm able to be Canadian and that I've been given that gift. I'm eternally grateful for that. And I believe that our country is so special and that this decision, I have maybe only 1% doubt, but that's it, that this decision is going to be a reflection of who we are as a country, of who we are as Canadians, and what we mean to the international landscape, specifically in the area of human rights, women's rights, because women's rights are human rights.
This is a human rights issue.
Yeah.
And I think that gets forgotten in family court.
Absolutely.
Right? I feel like if you are, seeking asylum or you're a refugee or what have you, we talk about human rights. But if you are a woman who has gone through years of coercive control or some type of intimate partner violence, human rights don't really matter.
Right. And I talk about this a lot about false equivalencies. So family court is the hotbed of false equivalencies, right?
Yeah.
Where, like it's the same having, your ex who just gave birth to your baby pumping milk and giving you that pumped milk so that you can feed the baby who is being fed at the breast of its mother and co-sleeping with its mother is the same. And and then if you say something about that, like I was on a Facebook group where family lawyers have, and I believe I left that group. But that group I think still exists. And there is this sense of false equivalencies is it's replete in what's going on this Facebook page. And I made some comments about that's just not real. Right. And I got a lot of pushback to the point that it was so stressful. I left that community and it really it was like, good for me that I left. Right. But it just showed me that people are, family lawyers are drinking the Kool-Aid for the court, and I know this for a fact because I personally know some of these people, right? They're very family oriented. If anybody was to come and take their kids and want to get bottle feed, right? That person would not stand for it.
Right.
And I have a real problem with that.
Yeah. Right.
I have a real problem with that. I just, that's why we have a problem in family court.
Yeah. Do you think this comes back to your earlier comment about how lawyers are living in fear? Like how they are scared to kind of step outside the box of what we've now deemed currently where parental rights seem to be trumping the best interests of the children.
And human rights.
In definitely human rights. But in my opinion, take it or leave it, is that coming back to this fear of being different, of being the face of change, of stepping outside and putting yourself at risk? Or is it the Kool-Aid's really powerful?
I think it...
This episode was written and created by Alex Howard and Amanda Silver, produced, edited, and engineered by RTF Productions. Make sure to rate and review our show if you loved it, and give us a follow on Apple Podcasts, Spotify, or wherever you stream your podcast to stay up to date on all upcoming episodes. Thanks for listening, and go easy on us. We're not your ex.